Great. Welcome, everybody. It is a special meeting of the Oil Conservation Commission on August 27th. It is 10:16 a.m. I am Adrienne Sandoval. I am chair of the Oil Conservation Commission and director of the Oil Conservation Division. Also with us today we have two other commissioners. Mr. Bloom, would you introduce yourself, please?
Yes, hi, good morning, everyone. I'm Greg Bloom, the designee of the Commissioner of Public Land, Stephanie Garcia-Richard. Thanks.
Thank you. Mr. Warnell.
Good morning, Madam Chair. Terry Warnell, present.
Also with us today is Counsel of the Commission, Chris Moander, and Clerk to the Commission, Flory Davidson. First item on the agenda is approval of the agenda. Is there a motion to adopt the agenda today?
I'll move to adopt the agenda today.
Is there a second?
I second that motion.
Mr. Moander, would you do a roll call vote for us, please?
Yes, Commissioner Warnell.
Yes.
Commissioner Bloom.
Approve.
And Madam Chair.
Approve.
Motion passes.
Next and last item on the agenda is sunshine law training. And with that, I will hand it over to you, Mr. Moander.
Thank you, Madam Chair. All right, so let me get this. All right. Okay, so I think you guys know who I am, and this is just the intro slide. So I'm going to move on to the second one, if this will let me. So the first thing we're going to talk about today is the role of open government attorney as board or agency counsel. We've got, just to give you guys a thumbnail, our office structure is broken into civil and criminal affairs. And really the open government division falls under the civil affairs, but we're our own separate division. So we represent essentially the bulk of state boards and commissions. Our primary focus is on board and commission compliance with OMA and IPRA. So it's the Open Meetings Act and Inspection of Public Records Act. We also do contract review. We draft official opinions. We conduct bill analysis for the legislature during session, and other duties as assigned. That my division has a broad charge, and this is just kind of gives the highlights. And as this commission knows, our work can go well beyond that. The litigation division, so you guys have a sense of it, they handle primarily the administrative prosecution. They also handle defensive judges and some governmental entities, and then litigation is otherwise needed. Next slide. So the primary role of board, and we use the word board as shorthand for agency or commission. So please don't read into that beyond. It's a good word to use to communicate the concept. We provide independent legal advice specifically to members of the public body, but the public body is the client. So that means we don't represent any individual member, we represent the body. We also extend our representation and legal advice to certain agents of a board or agency. An example in this case is Florine, because she's so integral to the function of the commission. And then we also will provide advice to hearing officers. As the commission knows, we draft legal documents that includes, for example, rulemaking, findings of fact, etc., through either adjudication or rulemaking. We also represent that public body in court or legal proceedings, with some exceptions as they arise. One thing that is important for clients to know is we do not have an oversight role. In other words, we are not the watcher that watches the other watchers. And we have a policy role, but it is distinct from our clients. But it doesn't conflict with them. Really, there is no significant difference between an open government attorney's role and any other role, or any other attorney role. but we always try, we take the client's best or wishes and best interests, and we apply the law to try to make those things occur. Next slide. We are here to help with meetings, rulemaking, administrative processes, and we do provide guidance to even policy bodies. And this is important because, as the commission's seen, we're involved intimately with meetings and rulemaking. And when adjudications come up, our role is pretty significant as well. And it bears repeating, but I think this commission knows, when you guys need something from me, you let me know. I'm always there to help you guys. Next slide. So let's talk briefly about the attorney-client privilege. So the client in this case is the public body, which encompasses the members. And the privilege protects confidential communications made for the purpose of facilitating or providing professional legal services to a client. Only current members to a commission hold this privilege, and it may extend to staff if there's an agency relationship. That usually tends to end at either direct assistance to the commission, executive directors, depending on the nature of their role. In this instance, with this commission, the chair of the commission is also the executive director. That's distinct with this particular client. Communications to receive the privilege must be confidential. If a client discloses a communication, the privilege is waived. If the communication is not done in private, for example, this presentation today, there is no privilege. Oh, yeah, and I forgot we had the examples in here too. In order to preserve the attorney-client privilege, and this is pretty important, is after a member's term is expired, they resign, whatever the case may be, the confidentiality does extend, provided that former member does not disclose the communications. And I always encourage folks when they leave to preserve that, because it is important and there's value, because if you do that as a former member, you're maintaining the integrity of the commission or body you were once a part of. Next
Chris?
slide. Oh, yes, sir.
Where you say if you disclose there's no privilege, does that mean that if I have a private attorney-client privilege conversation with you and I later made that public or disclosed it, then the attorney-client privilege ends?
Correct. That is absolutely right. So I, as an attorney, am effectively unable to disclose outside. So generally, it would be something in the case of the commission. You'd probably need at least the quorum to have voted and a motion to be passed to have me or to waive that privilege, and then I could do it. Otherwise, it's going to take a crowbar and some unpleasant men to get me to disclose something. So it was something to keep in mind with that, Commissioner Bloom, is that any member can inadvertently or intentionally waive the privilege for the entire commission by waiving the privilege individually. In other words, if there's something that has been communicated confidentially from an attorney to you guys, and one of you decides to take that information public, then the commission loses the privilege. So it's a little different than if it's an individual representation.
Thanks. I just wanted to make sure I understood that. Thank you.
Yep. All right. So and for Commissioner Warnell's assistance, we're on slide 7, which posits questions. Does anyone have any additional questions about what I've presented thus far? Hearing nothing, I'll proceed to slide number 8. This will be a familiar topic to this body. It's administrative rulemaking. Next slide. So as a general overview of rulemaking, we've got federal laws, which include federal legislation, federal regulation, and really most importantly, at the federal level, there's a variety of guidance on rulemaking from the Supreme Court. And that's really what we're often working with, because federal laws usually aren't implicated. Then we have the state constitution, the New Mexico statutes, which I think everyone knows are passed by the legislature. And then we have the administrative code. And the administrative code are all the regulations and rules passed by various agencies, boards, commissions, and that's inclusive of in some certain officials. Now, in order for an administrative body to create administrative regulations, they must have statutory authority to promulgate rules, and the rules will be limited by the scope of that statutory authority. In the administrative realm, we generally use rules and regulations interchangeably. They generally mean the same thing. Next slide. So some of these would, I'm sorry, was there a question? Okay, so I'll keep going here. The State Rules Act, I think, as this commission knows, it forms sort of the crux of what's required to adopt and amend rules. This act is focused on public participation in the rulemaking process, which we will touch on further. Now, if a particular agency doesn't have either any rules as to how or regulations as to how they will promulgate their rules, my office has generated a default rule, and it's sort of a gap filler. This particular commission has a substantial set of regulations that are geared towards its rulemaking and adjudicatory procedure. It's covered, but it's unlikely this commission will need those rules. I tailored this presentation a bit to kind of illustrate and give some context here to what are the laws specifically that impact this particular body. We have the Oil and Gas Act, and I've listed several sections here that provide additional guidance and instruction to the commission on how rulemaking should proceed. And then we've had the OCC regulations, and it's the 19.15, the entire subsection addresses specifically the rulemaking for OCC. And I think the commission's relatively familiar with these because the commission just dealt with this year thus far 2 rulemakings. So next slide. So the process and overview. Now, this is a very general structure here. There are some unique aspects to how the OCC conducts its rulemakings, which I'll touch on. But you have the community, where what Madam Chair has referred to several times as sort of the community buy-in, where you've got not just the boards and committees, staff, but you also, in this case, have the division, potentially any other involved bodies. We could even include the community in that. So that's the preliminary effort in order to get the rule going. So then we have the preliminary drafts of the rules, and usually those are sent to the Assistant Attorney General for the body for review. In this case, OCD handles the bulk of that drafting, and my role is more limited than it would be with others. And then there'll be some updates. Usually there's some discussion. Most parties, well, I shouldn't say parties, most bodies and individuals who will be involved in the rulemaking, at this point, we have more discussion internally about what the rules should look like and the interests that are in competition. Then we have the final draft proposal sent to the commission for review at the public meeting, and that comes with a petition for rulemaking. And then the body, in this case, the commission, will vote on whether that body wishes to proceed with the rulemaking, which triggers the notice provisions that are always so much fun to go through. And once the notice has been properly published and everything is scheduled, then the public rulemaking is conducted to receive oral and written comment. And what I didn't note here, I mean, that's a bit of a misnomer, because for technical stuff, there's going to be far more than just discussion of the proposed rule in a public hearing. Generally, there's going to be technical evidence, testimony elicited, and cross-examination conducted of those witnesses. There are other, again, we're going back to my office's default rule, and there are some general guidelines in the statutes if an agency doesn't have its own rulemaking procedure. In this case, that doesn't pose a problem because the OCC has been pretty thorough in structuring its rulemaking rules. So then once the public hearing is conducted, the commission reviews the entire record in public comment and then adopts, amends, or rejects the proposed rule. Again, I think the commission's familiar with this process because it was just recently completed. And then once the rule is adopted, it's sent off to records archives, the Mexico Register. There's publication, all sorts of announcements to make sure the rule is known to the public. I noted elsewhere, pardon me, in this presentation that when the rule adoption, there's varying ways that can be official. Generally speaking, when we submit OCC rules, we insert the date of adoption by the commission as the effective date. If that's not done, there are default rules designed to give an effective date to a rule that doesn't otherwise specify. So next slide. And for Commissioner Warnell, we're on 12, in case there's a question. So the notice requirements are critical to rulemaking. And I will say that with OCC, Florine does a good job. She's monitored some of this. I monitor some of this. And of course, I give credit to Mr. Ames with the division because he usually does the initial drafting. So it's a summary of the full text of the proposed rule with proper strike-throughs for edits. Basically, the rule is presented with any deletions, additions, or if it's a wholesale new rule, it's the full text of the rule. There will be a short explanation of the purpose behind the rule, which is usually about a paragraph, and a citation to the specific legal authority that permits the commission to both consider and subsequently adopt the rule if it so chooses. Then there's also information on how a copy of that document can be fully obtained, which is inclusive of the text, technical information, and so on. The commission and the division both utilize their portal for this purpose, which is good because it is easy to use. There's information on how public comments may be submitted. That's usually modified a bit at the hearing where the commission will vote on whether or not to take up the rulemaking. Additionally, the notice will have information about the hearing itself. And so with the public comments versus participation, really, there's two types of public comment. There's the written and there's the oral, and that oral would be participation usually in the hearing. And then the citation for technical information, and that's particularly important for the commission because it begins to form the basis of what usually ends up as the primary evidence or the key evidence used by the division to advance the rule if the division is the petitioner. Next slide. So public participation is key, and that's why the State Rules Act is really built around the assumption, or not the assumption, but the principle that the public should have the greatest possible amount of both information and ability to access rulemaking because it is so distinct from legislation. And the theory behind that is legislators are voted for, and so that's how the public has its participation secured in that process, because administrative processes are, in a sense, less democratic that way. The policies and procedure adopted towards rulemaking is to ensure that the public has the ability to make these comments directly. So the public always has a right to participate in the process of rulemaking, and they do have a right to comment. So the notice has to be published in the New Mexico Register at least 30 days prior to the hearing. And what that usually means is that it needs to be completed about 60 days. Well, actually, let me take that back, 45 days before the hearing, because there is a delay in the printing of the register. So it always helps to factor in the sort of institutional timelines that will affect these publications. And in fact, one of the big reasons why rulemaking fails is because this 30-day requirement gets violated because people did not properly time their submissions. The notice will go to the Sunshine portal for public access as well. And I think a lot of folks access the division's website because it's pretty easy. And if you're involved in anything involving the commission, you know where that is. There's the Legislative Counsel Service, which also does the publication of the notice. And then anyone who's requested the notice of rulemakings, this is kind of becoming a little on the antiquarian side because it used to be that the newspapers and like local publications would request to be noticed and they would publish them. That's diminishing. Turning to public comment itself, the public can submit comments in writing before the hearing, and this commission gives significant amounts of time for that to occur. And comments must be posted to agency website within 3 days of receipt. Florine puts these up pretty rapidly to the case file on the division's website. And then the actual rule hearing is either conducted by a hearing officer or a full board. This commission has a preference for using a hearing officer, which is obviously okay. And the public can comment at the rule hearing and even submit evidence. Now, if a public commenter elects to submit evidence, that does, depending on the nature of the evidence, can submit them to cross-examination. The general rule is if they're submitting technical testimony, that pretty well guarantees that all the attorneys at the hearing will have a right of cross-examination. Next slide. So when it comes to adoptions of a rule, and I just realized there's a formatting on the word rule that I did not catch. So, and the commission has the right to adopt, amend, or reject proposed rules. Again, any changes or adoptions, amendments or adoptions, they must be considered within the scope of the noticed rulemaking. I believe the commission encountered this issue at a prior rulemaking. There was an effort to expand a purported effort to expand a rule beyond the scope of the noticed rulemaking. And there was a discussion about adopting, for example, federal principles of rulemaking to New Mexico, and quite a bit of discussion about that. At the end of it all, there's a concise explanatory statement that does detail the commission's findings, determinations, recitation of legal authority. That is, I think the commission would agree that those are usually not terribly concise, but they do get the point across, and they should be a good basic reference. So somebody who wants to know why a rule was treated the way it was by the commission, that would be the sort of the keystone to that analysis. And the reasons for adopting, as I discussed, reasons for adopting, reasons for rejecting, and that statement's filed with the adopted rule, and it is available to the public by this commission. Next slide. So final rules, which in other words is saying putting them into the New Mexico Administrative Code. All final rules generally adopt or they add or amend to the code, and they become law. The proposed rules that turn into final rules become law effective on the date in the rule, or if that isn't addressed, the date of publication. Next slide. Questions about rulemaking? Going once, going twice, sold. Next slide. So we're going to shift a bit to the Open Meetings Act, which is a law the commission's pretty familiar with, and then Inspection of Public Records Act. And I think that particular law, it's less important to the commission's day-to-day business, but I think it's important that the commission members understand how that law works. Next slide. So the New Mexico Open Meetings Act, it's New Mexico statutes sections 10-15-1 through 4. Pretty short act with a whole lot of power built into it. Next slide. So OMA is alongside the State Rules Act. It centers on that principle: the public's entitled to the greatest possible information about governmental affairs, and representative government always depends on an informed electorate. one of the key points is there's no closed meetings for formation of public policy, and really what's important for this commission is conduct of business by vote. So in other words, if there's a need for a closed session, that the vote for action, or actually really the better way to put it is actual body action after a closed session must be done publicly. This really does apply largely to RLD boards, and because they tend to do a lot of closed sessions, but anytime there might be the need for a closed session, there needs to be a vote for action at the end of that. For most instances, there are exceptions. So all meetings of this commission are public meetings and anyone can attend. And the commission has to make reasonable efforts to accommodate audio and video recordings. I will point out here, I think the commission has done extremely well on that. It's not been an issue as long as I've been counsel for the commission. Next slide. So who is subject to OMA? Well, public bodies are, and the definition of a public body is a board, commission, administrative adjudicatory body, policy-making body of any state agency or political subdivision. So it's extraordinarily broad and covers essentially all administrative bodies that you can think of. So anytime there's a meeting of a public body, there must be a quorum. And the quorum can be defined in any number of ways. For our purposes, though, I think the quorum has to be 2 out of the 3 commissioners, because this body has a small composition. And if you have a quorum, you get to formulate public policy, if that's your agency's charge, discuss public business, which essentially covers everything outside a few exceptions in OMA, and take any action. And the word any really does mean any. If a public body is going to take action, that includes voting, that includes anything that's finance, that includes policy. So it's really any administrative agency, if it wants to do a thing, whatever that thing is, it's got to be subject to the quorum and done in public. Now, the act doesn't technically apply to advisory bodies, but my view is best practice is always to apply OMA. It removes any question about what that advisory body has been doing. OMA also includes bodies that have delegated authority. You can't delegate authority to skirt around OMA, and if you're going to generate a binding decision or action, which is any action in terms of a legal sense, that must be done in public, and it must be done by the body. We've had instances over the years of agencies who work to delegate decision making in such a way as to obfuscate it, and that's a no-no. Next slide. Quorums. OMA applies to all meetings of a quorum. We've touched on that briefly. Generally, it's a majority. The common law, if there is nothing to the contrary, the common law applies. And so it's 50% plus positive X. So the majority. And must not, quorums should not happen on subcommittees. That's more of an issue for larger bodies than the commission in terms of their numbers. Rolling quorums are a consistent issue that show up, and it's where members are not present together at the same time and place. In other words, a meeting, and there are separate conversations held in person or telephone. Really, these tend to show up mostly in emails because people don't understand how to avoid those rolling quorums. And so this is where if this commission does a good job on not doing this, but you'd want to be careful that if you are communicating with anyone, I mean, frankly, with this commission, individual members probably shouldn't be talking to each other at all, because 2 out of 3 constitutes a quorum, and that's pretty difficult to avoid. Next slide. What's not subject to OMA? And what OMA pertains to public business, not social situations. A good example of this, which I'm going to throw a hypothetical out here shortly, is commissioners, a few of them end up going out to dinner, and they talk about baseball, and they do not discuss any business. So OMA doesn't apply to like accidental, like, encounters of other members in public. There's no requirement for members to pretend the other person doesn't exist, anything that extreme. And there are ways to avoid the appearance of violations, because like so much with the sunshine laws, the appearance is often worse than the actual purported violation. And that's, it's similar to people talk about conflicts of interest. It's the same concept there. Usually the appearance of it is far worse than the actual problem, but avoiding appearances goes a long way to avoiding issues. Next slide. So here's an example, and I'm going to want a little feedback. 2 members of a 3-member school board, should sound familiar to this body, attend a retirement party of the district's longtime superintendent. While at the party, the board members have a long conversation about the upcoming baseball season. Was this a violation of OMA? Anyone?
No.
No.
That is the correct answer. That is not a violation of OMA. And the reason being is they are not discussing or engaging in any public business. This is a social gathering. So after a meeting, one of these board members sends text messages to the other using personal cell phones, urging him to vote in favor of the proposed budget at the next meeting. The other board member texts back that he definitely plans to vote in favor of the budget. Now, I'm going to remind us all of the little key factor. This is a 3-member school board. Was this a violation of OMA?
Yes.
That is correct. And the reason for that is because they were discussing business, and they were doing so even not just discussing business, they were discussing business as a quorum, because it's a three-member body. And it was not done at a public hearing. It was done through non-public means. Next slide. So meeting notices generally, there are some little differences in here that OCC does. Reasonable advance notice of all meetings, and that applies to any meeting conducted by a body. There is no such thing as a permissible secret meeting. Reasonable notice has to be determined by the commission or by the agency once a year. The custom is to adopt an annual OMA resolution. This commission's got some of its own rules in place that are very particular, which is somewhat unique because they've turned, or this commission's turned reasonable notice into a regulation, which is good. So the notice must include date, time, and location pretty clearly, and then an agenda. This commission posts its agenda with the notice, and these notices must be provided at a minimum. They need to be posted or published in a place or manner accessible to the public. Now, the health orders and some other orders that are in place currently through the governor, they have modified some of this, and we anticipate that will probably, these requirements will change to account for that. If any broadcast station or newspaper makes a request for written notice, then it must be supplied to them as well. And then other requirements found by the public body to be reasonable. To touch on that just briefly, at this point, that includes the Zoom information, call-in numbers, and really it's all about accessibility to the public. And from my perspective, I'm not speaking for my office, it does look like to me that Zoom has really, like the video conferencing has kind of taken over some of this and actually enhanced accessibility. So we'll see what happens as those orders shift and legislation changes. Next slide. So there's general deadlines, and these are always good to kind of have in the back of one's mind. Regular meetings notice, you generally want 10 days. The agenda has to be out at least 72 hours in advance. That's the 3-day rule is what I talk to client, how I describe it to clients. Special meetings, you need at least 3 days, and the agenda needs to be out at roughly the same as well. When meetings tend to go under for an agency, oftentimes it has to do with nothing more or less than failing to get the notice up in a timely fashion. This commission usually has the notices up 2 full weeks in advance, which is quite good. Emergency meetings, these should be extremely rare. The requirement for that is a threat to public health, safety, or imminent or irreparable financial harm to a public body. And 24 hours or less, depending on the nature of the emergency, is permitted. A good example of this is like if there's actually, it's actually hard to find some of these. I think DFA might have them on occasion as needed, but they should be extraordinarily rare. Next slide. So let's talk about an example. The Village Board of Trustees planned several months to call a regular meeting on March 10th. On March 5th, the village clerk realizes he forgot to post any notice for the meeting. Can the village call a special meeting instead and go forward as planned?
I don't believe so.
What's up? What was that, Commissioner Bloom?
I said I would not believe that would be possible.
So that would be correct. And the reason for that is that when you have regular, shouldn't have done that. When you have regular meetings, those are known quantities, and the expectation is that they will be treated as such. Trying to convert a regular meeting to a special meeting due to notice issues would be a violation of OMA. Next slide. So let's talk about I keep pressing the wrong button. Agendas. So notices must include an agenda or how to get one. So this is a particular problem, is when the items of business are not specific, and it's reasonably specific. So when I talk to clients about what does this mean, like how specific do we need to get, it's not a flaw to be fairly detailed in what's going to be discussed, because the commission is providing information to the public about what it intends to do or consider. This often comes as a problem when a body wants to go into a closed session under OMA, and they don't list exactly what's going to be considered. And there can be, like an example would be if there's detailed litigation issues that need to be discussed and there's no case number and no case caption, it can generate a problem. So no action can be taken on a business item unless it is on the final agenda, which has to be posted at least 3 days in advance. There's exceptions for public emergencies and bodies that meet more than once per week. I don't think that second exception really applies to this commission. Next slide. So here's an example of a pretty straightforward, I made a typo. So fictitious agency, I don't know how I did that. But you call to order, like we did this morning, approval of meeting agenda. Usually there's a minutes approval, discussion of old business. And so here's an example that it was easy to see kind of how things ought to look. Adjudicatory matter, case X, another one, case Y, hearing on proposed rulemaking, and case Z. You'll notice that I put it like the case numbers are an emphasis here because that helps the public identify exactly what matter the body is going to consider. In this one, I didn't put in any public comment because that wasn't necessary at this hearing. Next slide. And just to help Commissioner Warnell, we're on slide 29. So agendas. I pulled out the first agenda because it wasn't a very good one for this commission. Sue, a member of fictitious licensing board, is preparing for the board's next meeting on Friday. The meeting is scheduled for Friday at 5 p.m. I don't know why you would do that, but so the staff put out the agenda on Tuesday at 5 p.m. The next morning on Wednesday at 8 a.m., Sue realizes she forgot to ask the staff to put a particular action item on the agenda. Can the staff add the action item to the agenda for Friday's meeting? As it's correct, that would be improper and a violation of OMA. Next slide. So let's talk about minutes. This is also an area that can be a little sticky for agencies. Minutes of all meetings must include date, time, and place, names of all members present and absent. Best practice generally dictates that party counsel for that public body, I hesitate to use the word the players, but the people who will be doing things at the hearing that are not just general members of the public should probably be added as well. I hear a lot about people who essentially want minutes that would look like something that, for example, Mary, our court reporter, would generate. That is not what minutes are for. They are designed to convey the general substance of what was done at the meeting. And in particular, with that substance, the record of decisions made with it. In other words, what action did the body take? And in particular, each member voted should be, whoever voted and how should probably go into the minutes. No secret ballots. With this commission, we do a roll call vote, so there's multiple records of how votes were conducted. Generally, minutes need to be prepared within 10 working days, so 2 business weeks, and they must be considered at the next meeting. And there is some debate about whether that has to be the case if there is an emergency or a special meeting where there's something to be done that may not be in the norm, like, for example, today. And the inspection, that's a point too, where if any member wants to inspect these documents, even drafts, they're allowed to do so. Drafts of minutes are also subject to IPRA. So something to just keep in mind, that there can be requests coming from the public to take a look at those minutes before they're even finalized and adopted. Next slide. So let's talk briefly about open meetings and COVID. It's been a recurring theme, and this commission has dealt with it admirably. Generally, public bodies have to meet in person. COVID has created an ongoing exception to that rule, albeit temporarily. Virtual telephonic appearances during states of emergency are permitted, which is why the current orders and prior orders have allowed these meetings to be conducted, for example, on WebEx. The meeting notice must include connectivity information, and the best practice is on the agenda too, which this commission does. My office's guidelines, which this commission has adopted into its own processes and procedures, provide alternative means of attendance to the public. At this point, it's pretty much the only means is going to be digital, whether it's by phone or by video. Announce members of public body participating remotely. All members must be audible when speaking. This is all, I think that at this point, this commission knows this stuff by heart, but suspend discussion when audio video is interrupted. All votes are by roll call vote, and produce and maintain a recording of the meeting. Next slide. Emergency meetings, the term of art is the requirements for notice and agenda are relaxed. Emergency is an unforeseen circumstance that, if not addressed, is going to immediately by the public body will result in injury, damage to persons, property, substantial loss to the public body. If an emergency meeting is called, the body that calls it must submit a report to my office, and that's going to need to detail it's going to be a detailed explanation of why the emergency meeting was needed and why it met the definition of an emergency. To reiterate, COVID-19 does not necessarily authorize all emergency meetings. COVID-19 and all the kerfluffle around it just simply doesn't create automatic emergency meetings as a matter of law. Next slide. So closed meetings generally, they are private meetings that exclude the public. OMA permits closed meetings, but does not require, or let me rephrase that, closed sessions does not require them. There's a bit of a cultural myth that OMA requires certain things to be done behind closed doors. That's not true. But I think it's worth looking at the idea that there's a policy behind that exception in OMA. And part of that's to respects privacy, like with licensees. And it also, sometimes there are business items that a public body needs to deal with that are sensitive and may be subject, for example, to an attorney-client privilege, which is one of the litigation exceptions. Alternatively, there may be personnel issues that need to be addressed by a body, and it makes sense that the public body might want to keep those quiet. However, as a reminder, whatever goes on in that closed session, and there must be addressed in some capacity afterwards, and usually that's going to be with a action item by the commission. If a body thinks there will be a need for a closed session, the agenda item that will be subject to it has to qualify for one of the exceptions. There's 10. There is no catch-all, and these exceptions are quite limited. And almost always there has to be action taken in open session after the closed session. And closed sessions can occur at a separate closed meeting in and of itself, or a closed session during an open meeting, the latter being the most common. There are procedures that must be conducted. It is my role to provide and support those procedures to make sure that the body's complying with requirements for closed sessions. Now, I noted here OCC generally does not use or need closed sessions. It's pretty rare the commission has these, but they can come up, and we will address those accordingly. Probably a brief example is when I give a litigation update. That you've and the public has probably noticed, I don't delve into the particulars. I generally advise about procedural status and anticipated procedural events, which all generally stem out of a public record. Next slide. So in closing an open meeting, the requirements are you need a motion citing, and these two prongs are important. Legal authority for the closure, which usually be a reference to the specific subsection of OMA, and it's subsection H, if memory serves, that contains all the exceptions. And then the topic to be discussed with reasonable specificity. Again, I use an example because I think it's the cleanest one of a licensee before an RLD board. You will need to cite that licensee's case if you're going to have a closed session about what to do with the license. And there must be a roll call vote to close the meeting or close that session down. After the body has conducted its closed session, the body needs to make a statement in open session confirming that the topics discussed were limited to those that were contained in the motion to close. It's simple, not usually very complicated, can be overlooked if a body is not careful. Next slide. So let's give an example here. The chair says I'll entertain a motion to enter in a closed session. Number one moves that body enter in a closed session. Second, the motion to enter in a closed session has been made and seconded. Any discussion? Seeing none, all in favor say aye. Ayes have it. We're now in closed session. What does the commission think about that approach to closing a session? Any thoughts? Everyone's all quiet.
We didn't give a reason to close it, right?
Right. They did not cite to the issues to be discussed with reasonable specificity. They also didn't cite any authority that allows them to do that. So this would be a flawed attempt to enter closed session, and it would render anything occurring in that closed session, including the subsequent vote in front of in open session, void. Legally, it would be void, and the body would have to do it again if they wanted to do it correctly. Next slide. So let's take a look at this one to probably put a finer point on this. Chair says that he or she will entertain a motion to enter in a closed session. And member one says that they wish to move the board enter into closed session as authorized by the licensing exception of the Open Meetings Act to discuss disciplinary matters as listed on the agenda. This is member two seconds. The motion to enter in closed session has been seconded or made and seconded per the chair. A roll call vote is taken, and the chair, which passes, the motion to enter in a closed session carries. Let the record show that the commission entered into closed session at blank AM PM. We are off the record. Is that a proper way to close a session?
Don't they still need to cite the authority?
Well, I agree with you, Madam Chair, that what I would recommend here, this is probably sufficient, but I would counsel that licensing exception should be referenced as a statute. all the way down to the specific subsection. Reference to disciplinary matters listed on the agenda is probably pretty safe. Again, though, I'd recommend particularity. Okay, like if there are cases under consideration, whether it's body litigation or a licensee issue, probably should list those verbally on the record or orally on the record. So this is sufficient, but I would not view this example as a best practice. Next slide. So closed meeting minutes, well, there really aren't a whole lot. So the minutes must reflect the closed session entrance and exit and the matters discussed. Now note here that matters discussed is roughly similar to the reasonable specificity that needs to be on the agenda. Minutes from an open meeting, however, so that's the remainder of the meeting in most instances. The matters discussed in closed session, again, confirming we're limited to those specified in the motion to disclose. Next slide. So let's talk briefly. I'm not going to go through all of these exceptions in detail today because some of these just aren't really going to be an issue. I'm going to hit the highlights, but this is a list of the 10 with some notes. At the bottom, the OCC action will rarely follow these exceptions, but cases do arise or may arise from time to time, so it is worthwhile looking through. We've got the main one is the licensing, common issue, followed by deliberations of administrative adjudicatory proceeding. Student loan information, collective bargaining, purchasing, the ones that likely this commission tend to run into will be 7. The pending or threatened litigation that can come up. But really, it all is a case-by-case basis. You sort of don't know what's going to land on your plate that may require this in many instances. Next slide. So I kept licensing in here because I think this one, it just makes it it's a good, easy, digestible example. It's deliberation in connection with an issue with a license holder's license. It doesn't apply, it applies to individuals, not all licensees, and it doesn't apply to any hearings. And this is good to consider because it's a common theme through the OMA exceptions. The exceptions don't apply to hearings where evidence is offered or going to be rebutted. All hearings that are going to involve evidence have to be done publicly, which is really no different than a jury trial is in a state court or federal court hearing. Final actions taken at an open meeting. And I think that puts a good point on that when you come out of these sessions, there's going to need to be usually final action. And if there is, it has to be done in an open meeting. Next slide. Administrative adjudications. This is all this is optional. The OCC tends to do most of these things in open session. Primarily because it's dealing with commercial bodies and we don't have a lot of sensitive personal information. But this exception covers deliberations in connection with an adjudicatory proceeding. So that an adjudicatory proceeding is usually brought by or against a person before a public body where there's legal rights, duties, or privileges at issue that need to be determined by the public body. So this is like I said, the commission has the option of this. I think that its practice as it does it now is perfectly acceptable. But if the commission were to choose to do that, the hearing's got to be public. And if there's closed session deliberations, final action has to take place in a public meeting. And as I noted here, I think it may apply to OCC adjudications, but it's not required, again, by OMA. Next slide. Oh, and for purposes of Commissioner Warnell, I'm proceeding to slide 41. Litigation covers the exception in OMA, covers discussion of pending litigation or threatened litigation. That really means, to be particular about it, it's litigation where the public body is or may become a participant, which was really another way of saying that the public body is going to be a formal party or might be a third party in interest in the litigation. It's the only exception that expressly allows closed meeting to discuss attorney-client privilege matters. I noted here, as when I do my presentation, it does not run afoul of the attorney-client privilege, doesn't necessitate closed session. Next slide. So who does enforcement of OMA? My office. Private individuals do have a cause of action. What OMA allows, though, is written notice to the public body is required by a private actor. And really what that is allows private individuals to politely request that the body rectify or remedy, or in legal terms, cure its error. And the public body has 15 days to act on the alleged violation. If the body doesn't do that and the private individual elects to file suit under OMA, which they're permitted to do, there is a fee shifting and cost shifting provision in the Act, which allows that individual to recover reasonable litigation costs and attorney's fees. The Commission knows cost and fee shifting provisions are generally put into a statute to deter because they can be quite costly, and especially unsurprisingly, the attorney's fees. So actions taken in violation of the Act may be deemed invalid. There's a presumption that the public body complied with OMA, but as I mentioned earlier with the closed session stuff, if you proceed into closed session improperly, effectively anything that proceeds from that is going to be a legal nullity. Individuals who violate OMA may be criminally charged with a full misdemeanor and up to $500 per violation. Usually those violations need to be pretty clearly volitional because violations of OMA can and do happen. These things simply are part of the process. When they do happen, it's incumbent on both counsel for the agency and the agency to remedy that. Next slide. So just to do a bit of a recap on OMA, we've got the COVID-19 issues with allowing public to attend and comment, being cognizant of online attendance, speaking slowly, which helps our court reporter, and Lord knows I violate this recommendation all the time unintentionally, and speak clearly. Halt meetings when technical glitches occur. What comes to mind is the rulemaking in January. We dealt with these intermittently, and we all handled them very well. Avoid rolling quorums, and a reminder that action cannot take place in a closed session. Next slide. Best practices. Plan in advance for all meetings. I feel like this should go without saying, but I have to say it anyway. If you want items on the agenda, and ask at least a week in advance of a meeting to get them on. This really shows up with parties that may sometimes want to get things on an agenda, and review meeting packets in advance to shorten closed sessions if you have them. But frankly, this applies to everything, making sure you've read your pleadings if that's what's at issue. Reading the notices of rulemaking, being conversant in the subject matter that's going to be before you. Avoid emails when possible, addressing public business to other commission members. I think we all understand that. And if a member of the public raises an issue outside of a meeting, I have not seen this all that often, that issue should be forwarded to staff. So that way, well, at least in this instance, Florine, and consult with your counsel before responding, and don't discuss that with a quorum of commission members outside a meeting. Next slide. All right, so now we're going to talk about IPRA, and this should go fairly smoothly. IPRA is a simple statute that generates an abnormal amount of difficulty, it seems. Next slide. Oh, and I'll read this in for Mary, section 14-2-1 through subsection 12. Next slide. So IPRA is another example of opening the books to the public. It allows inspection and copying of public records, and those are broadly defined to include any record or document held by or on behalf of a public body when it relates to public business. IPRA, the default rule, we favor disclosure. There are some specific requirements that impact whether or not a document will be disclosed. Exceptions are generally, but not always, discretionary, and depending on the agency, disciplinary records are not automatically exempt from disclosure. That's a big issue that shows up. Good examples that come to mind are law enforcement disciplinary records have been the source of voluminous litigation. Disciplinary records of licensees, disciplinary records of really, I mean, physicians, et cetera. Those are the hot ticket items that tend to draw some attention. Board members' records are potentially subject to IPRA, but only when those records relate to public business. And that occurs even when using a private cell phone or email, and it still applies even after a particular member has left public service. So IPRA has a long tail in that regard. Subcommittee documents and drafts are subject to IPRA. Generally speaking, drafts of pretty much any kind are subject to IPRA. Next slide. Common exceptions. PPI, well, it's sort of a PPI, personal or protected personal identifier information. It runs in tandem with like HIPAA and tax law. The idea that any sort of personal identifying information should not be disclosed. You can do a variety of things with a document to comply with this and avoid disclosure. Blackouts, sometimes bodies choose to fight whether a document itself should be disclosed. Usually we're talking about social security numbers, addresses, things of that nature. Medical records, this IPRA complies with HIPAA. There's a procedure to get those. Attorney-client privilege documents, and then letters of recommendation concerning employment, licensing, or permits. So the reason this is an interesting exception, and the reason why this exception exists is because it prohibits disclosure of documents that contain these personal opinions. So in other words, opinions that aren't going to be buttressed by any fact. So I think Al is a jerk and should not be promoted. That's not going to get disclosed. Why? That's just my subjective personal opinion. It's not backed by anything substantive. And then trade secrets. These are probably less applicable. They're rare, but that's one option where, for example, if trade secrets were being for a particular mining system might come in front of the Mining Commission, those would be protected. Next slide. So I think this is probably IPRA in a nutshell for purposes of anybody dealing with it. This is the timeline, and it comes at you really, really fast, and especially when you're digging through a pile of records. So we've got day one, a request received by records custodian. 3 business days later, a custodian must send either the requested documents or send what's called a 3-day letter, which basically says, I've got a large volume of documents I've got to go through. I'm not prepared to disclose them yet. The 3-day letter really only buys time up to calendar day 15, so 2 weeks. At that point, on day 15, it's a bit of a drop dead deadline. Provide all requested records or send a denial letter saying we're not turning them over, or a broad and burdensome letter, which means that we are still working on these documents. And this is where there's a bit of a tail on IPRA. If the custodian sends a broad and burdensome letter, then it's contingent on the custodian to figure out exactly how much longer they think they need. Reasonable amounts of time vary based on volume of documents. It also is based on the detail of the documents as well as some of the substance. Financial documents generally going to take longer than typewritten, online submitted complaint forms. So it all depends on what's being requested. Now we'll talk about the flip side of this. If this strict timeline is not complied with. Next slide. Let me look ahead real quick. Oh, you know what? So before I proceed here, actually, and Commissioner Warnell, I'm going to be on slide 59. So there are a variety of things that can happen with an IPRA violation. So there can be up to $100 a day, continuous fines that get accrued. This can become extremely expensive. The lawsuits for IPRA violations are pretty prevalent. So the risk that a body always runs is that it's going to just continue this dogpiling of $100 a day fines. There's also, similar to OMA, there's criminal and there's civil remedies available. The civil remedies are going to be roughly the same as they were with IPRA in terms of my office can enforce this, a private actor can enforce this. These tend to be brought primarily from private actors because my office does handle IPRA requests and evaluating and determining whether an agency or body has properly responded. So that's the best practice is to defer to disclosure. If not, talk to your assistant attorney general about that. Go through and explain why you think these documents shouldn't be disclosed. So back to slide 49. Your records are subject to IPRA to the extent they relate to business. Generally, you should create a separate email account for business. In this instance, I believe that's been done. 2 out of the 3 members here have state accounts anyway. But be mindful of the records that you do create. And if someone contacts you asking for records, that's day one. That's day one, because it doesn't have to be a written request. And this is where it would be nice if all requests came in writing, because that simplifies the matter. But if you are orally requested for record, or you are orally solicited for records, contact your counsel. Oh, and I have RLD in here and I shouldn't have. You want to contact me immediately and get the ball rolling, because you want to generate records for review as soon as practicable. Next slide. Questions about IPRA?
Can I just ask a question? Hold on, it's Mary. I just kicked my mic. I just kicked my microphone cord out, so let me just put it back in. Sorry. Okay, I'm good. I didn't miss anything. This is just for my backup recording.
Oh, no problem, no problem.
Okay,
and actually, Mary, this is a fine example of best practices under the health orders when there's a technical issue that we should pause the meeting or the hearing, which we just did. All right, so are there any questions about IPRA? All right. Moving on to slide 51, we're going to talk about what's that?
One question.
Sure.
What about personal notes that we generate during, I don't know, rulemaking or some other aspect of the hearing?
So those would likely fall under IPRA. Those would likely fall under IPRA, yes.
That's what I thought. Okay.
Which I want to, I don't want any commissioner to be shy about some of those things. It's an interesting issue. I'm going to suggest perhaps you and I should have a longer discussion about that later. Okay. All right, so now we're going to talk about the GCA, the Governmental Conduct Act. This is a pain of a law because it's pretty straightforward, but it's oftentimes not at the forefront of agency employees. It's usually employees, but members' minds. And so I want to touch on that today with you all. So I'm going to move on to slide 52. So the GCA outlines basically it's your ethical and sort of professional, to an extent, standard of conduct and responsibilities to ensure that you and your peers are acting solely for the public interest and not in your own interest. Next slide. So this one's going to be a little drier because we're going to walk through these sections because it's easier. So the GCA applies to any elected or appointed official or employee of state or local government who receives any compensation really, or is eligible for per diem or mileage, which covers pretty much everybody who works for either state or local government. Next slide. The essence of the GCA really is public trust. You don't want the legislators or public officers or employees treating the public office as sort of a personal finance source. I mean, I think that we all agree with that. But they can't really, you can't use any state resources for personal gain. And that's really what it comes down to. Now, that's subsection 3A, 1016-3A. 10-16-3B also points out that everybody who works for the government needs to justify the confidence that's been placed in them, and they need to consider themselves operating at about the highest ethical duty that one really can. And what we're really talking about here, in a sense, and I'm not saying that's what this particular provision says specifically, is it's a fiduciary duty. It tends to be about the highest in the law, if not the highest. And so you're really operating as a fiduciary. In other words, am I being a good custodian of the resources that I've been given? Next slide. So in the New Mexico Office of the Attorney General Governmental Conduct Act Compliance Guide, we really emphasize the fact that government officers and employees must act honestly, diligently, transparently, fairly, within the limits of their lawful authority and with integrity, and then carry out the laws in accordance with legal principles, not any sort of personal gain. I think this really puts a good spin on this law, is understanding, and for agencies, the within limits of your lawful authority, that's staying in your lane and doing what your agency is charged to do and not trying to reach outside of that. Which is not to diminish the remaining qualities, but I think that's uniquely applicable to the agencies. Next slide. Improper influence. This is an interesting one. 10-16-2D. What this subsection really addresses is you're not taking bribes. There's no pay to play. Nothing of that nature. In other words, no quid pro quos for, I pay a member of a board to give me favorable treatment. That is specifically prohibited. It's so much of a concern that the legislature turned this into a 4th-degree felony. And while it's been a while, my criminal sentence law is a little rusty. I think that's up to 18 months, anywhere from a year to 18 months in prison. So it's not, I mean, it's a felony. It's pretty serious. Now, 10-16-3H provides an important definition as we start to move forward here, but an official act that's kind of a linchpin to this statute, because it's looking at what official acts were taken that, say, for example, generated the quid pro quo or were a result of it. And an official act means an official decision, recommendation, approval, disapproval, or any other action that involves the use of discretionary authority. And so you can see, for the example I gave, again, because it's simple, is if I'm a licensee and I'm in front of a licensing board and I offer something of value to a board member to ensure that my license is not revoked, and then ultimately the board doesn't revoke my license, that's an exercise of discretionary authority. And it would be a disapproval of the request to do whatever adverse thing was requested be done to me. Next slide. There's a prohibition on honorarium. And so in other words, I think most of us are familiar with the speaker fee and honoraria if you're not going to pay the speaker fee. Pardon me. You can't have anything over $100. There can be some reimbursement for meals, lodging, and travel. But the key here is you can't take any money for a speaking engagement or participation in like a speaking panel. One, I think this is a great way to prohibit people from making it a side business to utilize their office sort of indirectly to get personal gain or to really financial gain. But on the other hand, it also doesn't prevent members from speaking, and especially individuals who are charged with a sufficient level of authority where they might be able to speak for an agency or for a commission. Next slide. All right, this is the hot topic always under the Government Conduct Act. It's conflicts of interest and a duty to disclose. We want to remove all undue influence and abuse of office out of government. And therefore, all members, and generally when anybody joins a government entity in any way, they submit a conflict disclosure form to the state. However, that's not the end of it, because in some cases there's value in additional disclosures inside a particular agency. And for one of the examples of that is if that agency has a particularly public visible role in either regulating an industry or being affiliated with an industry, that beyond known disclosures, there's probably a need for something a little deeper. And in 10-16-4.2, we've got an internal written disclosure for that particular agency, and to disclose, for example, other employment as well to ensure there's no conflict there. So this runs deep. It feels extremely nosy at times, but at the same time, we're also looking to ensure the public, validate the public's confidence in us. Next slide. And going down a bit deeper on conflicts, there's the financial is really the big one. It's unlawful for a public official to take an official act that the primary purpose of is directly enhancing their financial position. So, and these three sections here, 10-16-4A-3B, they all work together here. And what they do is you've got in 4A is the strict prohibition of official acts being taken for personal gain. Then 10B is we have disqualification once the disclosure's been made, which is that's the preferred approach if a conflict is discovered, is a disqualification. And I would anticipate that most people, when they make that disclosure, understand that they're not going to be permitted there to be involved in that issue. Now, if you are working for an agency at any point in time and a conflict arises during your employment, you need to make that disclosure pretty rapidly as well. And it will need to be in writing. So really, let me check to see if this next slide. So there is one little exception that I don't encourage its application, but it's worth noting, is that if there's not a primary purpose of self-financial gain and the benefit to the public significantly outweighs the benefit to the member expressing or disclosing the conflict, there is a little bit of wiggle room on this, sort of incidental personal gain, where it's not the focus or intention. Those instances that applies are rare, and I always caution clients not to try to play games with these statutes, because there is a pretty straightforward process, and it's generally going to end in disqualification just for that issue alone. Next slide. Confidential information. You cannot, as a member of a public body, utilize confidential information gleaned during your participation in that role for any gain. You just can't do it. And frankly, this is one of the more odious violations that one could engage in, I feel, because a good example of this that comes to mind would be if you worked for TRD and you were just hoovering up all sorts of information that's not only state protected, but federal protected, so you can utilize it later. Bad idea, don't do it. Next slide. Contracts. This is pretty verbose. What we're looking at here is self-dealing in some capacity. I think in the recent example that illustrates this was recently the mayor of Las Vegas, New Mexico, was indicted for ensuring that contracts for city construction projects were given to, I think it was her boyfriend. This is exactly what is prohibited. So if there are contract and there are procedures for this that also go into into details in the Procurement Act, but to use the office and improperly influence the granting of contracts in such a way that it benefits you, benefits friends, family. The competitive process is designed to avoid this. I don't think the OCC deals with this a whole. I think this is more of a division issue, but it's just important to keep in mind that you can't pitch your buddy Bill's construction company as a single bid contractor in almost any instance and just get him the contract and let it go. No, that's prohibited. Next slide. The GCA has quite strong enforcement penalties. Probably not surprising that this statute, above all, has heavy-handed penalties. So aside from the new, well, they're not new anymore, I guess. The relatively young State Ethics Commission may take over investigation of GCA in violation. What they would do is allow the State Ethics Commission could elect to either refer the case to my office, refer it to the district attorney. They could refer it to another agency if they felt it was necessary, or they could refer it to the legislature. Most of the time, these referrals are going to go to either my office or the DA's office. So violations can result in a discipline, as one would expect, including separation from the body. Next slide. But really what folks want to know is less about being dismissed or removed and more about what it will cost you and what type of prison sentence may be attached to it. So we've got to, if you violate the Governmental Conduct Act and it's done knowingly or willfully, that's a misdemeanor. You can get fined for that, about $1,000 and not more than 1 year. Generally, for the sake of edification here, misdemeanor is any crime that carries a sentence of less than 1 year. Now, this is where things get all kind of crazy, is that does not preclude charges being filed for bribery, fraud, any of the other types of rather shady sort of criminality. Usually those charges are going to be bundled up with this. And now, what I do note here as well, or elsewhere in the GCA, there's felonies also sprinkled in here. This is the baseline crime. The State Ethics Commission may actually institute its own civil action in order to try to recover or recoup any losses that occurred due to violation of the Governmental Conduct Act. They can get anything ranging from a permanent injunction prohibiting, say, the contracted with party from ever being able to contract with the state again, restraining orders. They can get any sort of creative order that they might come up with, and there's a lot of them out there. But really, they can focus on getting the civil penalty, $250 per violation, but capped at $5,000. Next slide. Oh yeah, questions? Nothing. All right, something I do just briefly want to touch on. I didn't throw panels together for this. The new Civil Rights Act that was passed, that's now into effect, has essentially waived sovereign immunity for the bulk of the state period, the state government, if there's an allegation that the entity or individuals violated a civil right that is rooted in the state constitution. A good example of this that I think we'll see something come of this is due process violations of any kind and flavor. Now, what it means, sovereign immunity is an old common law doctrine. Basically says the king cannot be sued in his or her, well, his courts absent a waiver of that immunity. And so it comes from a long time ago, and it's been, a key part of American government since the founding. But what this means is that there's no longer the ability for the state government and its membership to say, Judge, they can't sue me. I'm part of the king. And so what that means for agencies is that they are now exposed to a certain degree of liability, and that liability is set at a cap of $2 million. And before anyone, panics about this, the way the statute's structured, it requires that the individual actors that have led to the suit, working in their scope and course of their duties, will not be named in the suit. The suit should be targeted to the entity. And the state of New Mexico, and there's going to be some discussion about this later, the statute says the agency, but really it would probably be paid for by the state. That they will cover costs of defense and it will cover the costs of any settlement or judgment. So in reality, it doesn't actually make it all the way down to the individual level, but it's important for the commission to at least know that there is a new door opened to actual substantive liability for state actors. Good news is anybody who would get sued individually really won't be, and then ultimately they will not be held personally liable. So we will see what happens as that matter is litigated, because it's obviously going to. All right, so this last slide is just contact info for my office generally. That concludes the end of my slideshow. It looks like it took longer than I thought. Are there any questions, concerns, anything like that that you guys would like to ask?
An excellent teacher.
Well, I appreciate that. I really do, like, truly. All right, well, I will relinquish the floor and return it back to Madam Chair. Oh, wait, I can stop sharing. There we go.
That was the last item on the agenda
Where
today.
is this button? And then I'm looking right at it, and it was blending in at the top of my PowerPoint.
Do any of the commissioners have any other items to address before we adjourn today?
Madam Chair, nothing. Thank you. Thank you, Mr. Moander.
Well, thank you all for having me. It's always a pleasure.
We will convene again on the 16th of September. So thanks everyone. It's 11:44 and we will end today's special meeting.
Bye, everybody.
Bye.
Good weekend.